We were on the subject of Judge Fields, and I want to give you an example of how wise he was in his manner of expression and wit. I was assistant county attorney, and I was prosecuting a paternity case because the lady and the child were being paid by DSS for child support, and the father was very able to pay child support. He's the city policeman for the city of Charleston. He just wouldn't acknowledge the child, and there wasn't much to be done other than have a hearing and determine paternity. And Judge Fields was the trial judge, and when it got to the end, he had to make a decision. Judge Fields, I like to imitate him because he was always so polite. He'd smile and shake his head at him. He said, I've known Officer Brown for many years. In fact, he testified in my court when I was municipal judge for the city of Charleston many times. And I found his testimony to be most credible. He said, but I would caution Officer Brown, just as in a DUI case, I left out something important to the story. The man had admitted that he had dated this woman for 2 years, but that he never had sex with her, and it wasn't his child. And Judge Fields said to him, just as in a DUI case, it's always better to admit you had 2 or 3 drinks. And he rapped the gavel and said, he's the father. Oh, he was great.
Absolutely. Judge, let me ask you, when you first got on the bench, how were cases assigned to judges, federal judges?
In the civil cases, there's a wheel, and it's a blind wheel. We don't know who's getting what.
Was this the way when you first got on the bench, too?
This is always.
Always. Okay.
Always. And even now, the civil cases are done that way. I don't know whether it's by tradition in South Carolina or what, but criminal cases were meted out by the chief judge. And the story goes it was done by Judge Martin when he was a chief judge, and he kept all the criminal cases. And then if he needed help, he'd assign one to somebody. And the story goes, and I'm sure this is true because I've heard it from too many people, that he did that because he didn't want Judge Blott to get any criminal cases, because Bubba Ness had told him, the former justice on the Supreme Court, Ness, who was a good friend of Judge Blott's and Judge Martin's, and he said, don't give any criminal cases to Saul because he's soft-hearted and he'll give him a baby Ruth instead of a sentence. So Martin kept the criminal cases, and I guess he made sure Saul didn't give out any baby Ruths. But later on, I'm trying to remember, and the chief judge had that authority, but later on, I think they just put us on a wheel, and the chief judge would balance big cases, like if you got a roof case or something, Dillon Roof, that's going to take up so much time and everything else, and they would take you off the wheel and let you handle that and adjust that way.
And once a civil case was assigned to you by the wheel, how does it process through your court after that?
Well, you first thing is it comes to you as a file. It's up to you to establish the procedure through a scheduling order. And what we do is I get in files and take a look at them and see what kind of cases they were, so I'd know what we were dealing with. And then my assistant Cindy would assign them to law clerks, try to balance their caseload and workload. And then she would take care of giving them a calendar and a time frame in which we needed it back. And if there was a motion pending, when we needed that back. And they'd analyze that and then bring it to me. And we did that throughout. When I came on the bench, I was told in, quote, judges school that I thought I would have plenty of time to sit and ponder and write great treatises, and that I didn't have the pressures I had as a trial lawyer. And we get to this judges school, and he says, you're not going to have time to do what you did as a trial lawyer. You won't be able to maintain the same level of involvement and intensity and excellence you did as a trial lawyer. So what I recommend you do to keep in touch with your values and make you feel good about what's going to happen, take one case and work it the way you would have in the law practice, and then deal with the others as you can. Well, I got 252 civil cases, and they were all stale, meaning they were all 3 years old or older. Well, not all of them, but a good many of them were. At the end of 3 years, you got to report the case to the Fourth Circuit as being stale if it hadn't been disposed of beginning to end in 3 years. And usually there's a reason if they're not. It's a trouble case, or nobody wants to try it, or the judge doesn't want to deal with it in a timely way. And then if the motion is older than 6 months on the docket, that gets reported to the Fourth Circuit. In addition to that 252 cases, and I'm trying not to misstate on the record the number, I had at least 100 cases of Social Security appeals and bankruptcy appeals. And I'm trying to remember whether we had the criminal cases separate from that, or some of those were mixed in with 252. But anyway, my mind, my recollection tells me I had like 400 and something cases to deal with, a good many of which were stale.
Well, these were Judge Perry's cases? Or
They came from all the judges. They have a balancing. When you get a new judge, everybody, depending on where you're stationed, seniority determines where you're stationed. That's another thing that was inefficient. When I came on the bench, I sat in Columbia, Florence, and Charleston. So judges were giving me cases from all those places. And every time you get a new judge, they have a reallocation of cases, and they might move a judge here or there. And when you get enough seniority, you go where you want to go and stay. But yeah, it was a constant kind of a thing. And it was very inefficient riding to Columbia and riding to Florence and still having to do all that at the same time. One of the big cases I handled was Souders versus Santee Cooper. The case was filed in 1993. Judge Blott had signed orders in it, Judge Norton had signed orders in it, and I came on in 95. And it was over 3 years old when I got it. It was such a mess, it was so complicated. I was pushing it to trial. And it was flooding of riparian landowners under the Santee Dam, and the Corps of Engineers had a formula by which they ordered Santee Cooper to spill water. They washed away people's yards, crops, timberland, you name it. They didn't care. I shouldn't say they didn't care. The hydroelectric was a paramount thing, saving pricing and water and all that stuff. I signed the last order in the case in 2011, which was for attorney's fees. That's how long it took to dispose of that. So I battled that thing that many years. And when I was done, you had to determine there were spillages in 93, 95, and 97 when the takings were inverse condemnation and trespass. And the lands were injured at what year and when did the statute run, and all kinds of issues. And then they determined halfway through the trial that there was a federal energy commission element that had never been briefed, and they bring it halfway through trial. So I said, no, it is what it is. We're going on with the trial, and we'll have to deal with it on appeal, because we're not starting over with a jury, kind of thing. Anyway, it went to the Fourth Circuit. I decided liability. Damages were so horrendous and so varied, it would be impossible. I didn't want to have to try all those. Sent it to Fourth Circuit to see if I was right on liability. Before we went into all that, they punted. They sent it back. So go do all your damage trials. In the middle of that, the government decided after this many years, the Corps of Engineers, I didn't have jurisdiction. I said, I wished I didn't, but I'm afraid I do. So I ruled I had it. They appealed that to the Federal Circuit in the midst of the proceedings. Federal Circuit said I'm right, I had jurisdiction, so I couldn't get rid of it. So anyway, it was a nightmare, and when it was finally done, I awarded damages as of the taking, which went back to 95, which meant that there was prejudgment interest from 95 up to 2011, and all the damages went sky high. I mean, it was just a nightmare.
Now,
I'm done.
you said when you get assigned when you get assigned a case that Cindy would take it and balance it out between the clerks, what did the clerks do with it at that point?
Well, going back to what they instructed us, when I was in law practice, you might recall, we dictated, and I dictated briefs, orders, whatever needed to be prepared, and I wrote my own. And I had Laura, who was fantastic, and then we had Hagar's wife, who would work at night, and she would type. So I would dictate and leave tapes and this and that. I come on the bench. I have 2 law clerks who are doing research, and they wrote their own stuff. And Cindy, who I would dictate things and leave, but she didn't have time running dockets and doing the stuff I'm talking about to do any of that. So what I said to the law clerks, and it turned out to be a great practice, and they liked it, and I found out later other judges did it too. It wasn't original with me, but it was necessary. I said, I don't want you to write me a recommendation. Go ahead and write the order the way you think it should be, and if I agree with it, we're going to sign it and get it out of here. I'm not going to worry about, excuse me, if it's well written, I'm not going to worry about which words you chose. We're getting rid of the case. So that's how we did it. And so they would prepare what is really a recommendation, but it was proposed order.
Yeah.
Right? And it works well. In fact, they'll all tell you that's what they really enjoyed. And I required them. Only had 2 law clerks that had a hard time doing it, to pull the trigger. Don't say I could rule this way or that way. You tell me what it is and why you think that, and I'll tell you whether I agree with it or not, because you don't have time to play around with it. And the discipline, instead of just taking one side or the other as you could on any brief, they had to make a decision and tell me why they did it, and I'd question them about it. And I looked at the record to see if I agreed with it, and I'd change it if I didn't. But it moved things along, and it gave them great experience.
Now, we talked about Cindy a few minutes ago. Tell us about Cindy.
Cindy was a force of nature and enjoyed being that. She's a very bright woman. She was married and had a 7-year-old child and was moving to Charleston.
Cindy Hubbard, we're talking about.
Yes,
Right.
Cindy Hubbard, Judge Cindy, as they refer to her here. And she likes that, but everybody use that both as a compliment and I'm sure sometimes as a complaint from people like Michael Scardato.
Did she really have a stamp that said deny, deny, deny?
That was just for Scardato. He was a former law partner of ours. But anyway, she would screen things that I asked her to screen, and somebody like Michael, and she would only do it with him, say, just let me talk to the judge, Cindy. She gave him such a hard time. She worked with him in the law practice. But anyway, she came to me from Columbus. She was the best paralegal in Nelson Mullins, according to Mullins, who sent her to me, and he said, she's moving to Charleston. I'm going to give you the first chance to hire her. Well, I called and interviewed her, and Lucas Paget needed a secretary, and it wasn't a fit for them because he was doing administrative work. She wanted to do trial work. And so I swapped. I gave him my paralegal, and I took her. She was really good, and she was very experienced, took no coaching or supervision, really, and was very aggressive in doing the work. She loved it. She later, as a judicial assistant, became the national president of the Judicial Assistants Association. She was that kind of a person. But anyway, after working for me at the law practice for a number of years, decided she wanted to be a school teacher. And she finished her degree while she was working for me at the law office. And that's one reason she left Columbia and come down and get her degree. She later went on and got her master's degree, decided she wanted to practice, wanted to teach. Went and taught, didn't like it. We didn't have room for her when she got finished and didn't like it. So she went to work for young Clement. And then when I went to the bench, rather than screen and hire people, I called her because I knew she could do the job, asked her if she'd be interested. And she took the job and came, and all total, we worked together 30 years, and it was a good arrangement for her and for me. And she right now offered to work for me in doing some things that I'm doing now, like mediations. And I said it wouldn't work with the time difference, you in San Francisco and me here. But she was most competent.
Now, she retired also this time.
She retired. In fact, law clerks finished the end of August, and I was going to retire. And we waited, and it was better for her. She had sufficient years, but it was better for her, for some reason, on the federal deal to retire at the end of October. So I waited until then and then retired, and so did she.
Now, we talked about the law clerks earlier, writing orders for you and et cetera. How did you go about hiring a law clerk?
Law clerks, you know, we used to get 200 applications from all around the country, the best and brightest, Harvard, Yale, Stanford, you name it. And the law schools, the deans asked us not to open them until a coordinated time, like September 3rd or something. And they had this system the federal court put online for applicants to apply, the Oscar system. Well, baloney. I don't have time to sit when there's 200 of them on your desk and go through them and screen them. So I did them when they came in. And what I learned was, if you're talking about the best and brightest in every class, every one of them can do the job, okay? The difference between the Harvard and the South Carolina graduate at that level is the Harvard person may have specialized in something that wasn't available to the person at the University of South Carolina. But so far as the constitutional issues and the work that we do, they could all do it. What I understood quickly was that, well, I brought this to the job really, is that a South Carolinian applying to a judge in New York is not going to get a heads up over a Harvard graduate. So I wanted to hire law clerks who were the best and brightest, but had some nexus to South Carolina so that they would stay here and practice. I don't want the brain drain going somewhere else after we train them. For example, there's a girl from St. Matthews who went to NC State and got an environmental engineering master's degree and went to Stanford Law School. And I hired her. And she right now is working for the Southern Law Institute. But she went to Stanford. She could go anywhere and get a job, but she wanted to work in South Carolina. I'd like somebody with her talents to stay here and work. So I hired her for that reason. And other people, I want them to stay here, and it's good for them. They know everybody in South Carolina if they're from the law school, and it's good for the practice and the other lawyers that they deal with.
How long did a clerk work for you? I keep on forgetting you're retired, Judge. I'm sorry.
Well, that's perfectly all right. I forget I'm retired too. Judges have a choice of how they do that. Some have lifetime clerks. You can only have one lifetime clerk, and the rest, you have two law clerks. The other one you would have to rotate. I always thought a lifetime clerk's great for a judge, and it's very convenient. But it takes away opportunities from other lawyers getting to have some of those experiences through rotating them. So what I decided was I would do 2-year terms. If you take, and a lot of judges did 1 year, but if you do 1 year, you're just getting them trained to where you want them when they're out looking for a job. So I thought it'd be great to have them 1 year training and learning, and you get the benefit of that full experience the second year before they have to start looking for a job. So the first time I came on the bench, initially when I came on the bench, the two law clerks I had were T.J. Parcell and Victor Rawl. And I said to them, I want 2-year terms, but I want to stagger them. So one of you needs to work either 1 year or 3 years. And I'll let y'all talk among yourselves, between yourselves, and decide who wants to do it and whether it'll be 1 year or 3 years. So they said, we both want to stay at least 2 years, and TJ said, I'll stay 3 years. So that's how it went. From now on, I rotated. It worked well.
Did generally, I know you said you look for the best and the brightest and with maybe some South Carolina connections. Over your years on the bench, have most of your law clerks worked out? And I don't want any names, Judge, for the record.
Yes, they have. I've only had 2 law clerks that I wasn't perfectly happy with. And I talked to them, and they agreed and understood why. And what I did with them was just told them that I thought they ought to finish up a year and then go find a job in a law practice, because didn't mean they weren't going to be good lawyers. They just weren't great law clerks. Right. Different talent, skill set to some degree. And both of them have turned out to be very, very good lawyers, so I was right, and I keep up with both of them.
How about the federal magistrates? How do they fit into your system, Judge?
That's a great system. You know, the federal judges some time ago voted to call them magistrate judges, but they wanted another title, which I thought was more appropriate. And I can't remember whether it was associate judge or something like that. And they handle all of the preliminary matters for us in criminal things. They're on call, which is not an easy thing. They handle pro se things that come so we don't get the fella off the street that wants to represent himself. They do reports and recommendations on all Social Security cases before we get them. They do the same thing on bankruptcy appeals. They do a lot of work, and they're very capable. We've been blessed with great magistrate judges, and we still are. They're just good.
Now, they're elected by the judges, actually.
The district judges vote on them. They seek applicants, and then they are appointed for a term of years, and I think it's 7 years.
Now, Judge, did you prefer jury or non-jury matters on the civil side?
Always prefer the jury trial, because I'd rather them make the decision than me. The jury trials are more fun because you got the citizens involved in the process. And the Seventh Amendment is a dear thing to have, and you want to use it. And juries, people like to criticize jury verdicts, but if they were in the courtroom and heard what the jury heard, they'd understand whatever the reason is that the jury brought back the verdict. Only once in a great while would you have a runaway jury, and usually there's something in the trial or the facts that cause that, like the Ford Pinto case, for example. But ordinarily, the jurors take the oath seriously, and they try hard to get it right, and most of the time they get it right, and I'm very proud of their effort. I'll tell you, I always want to serve on a jury, and you had the privilege of serving on a jury and learned a lot from it. And I think that it's an educational thing for anybody to serve on a jury, and you have to feel good about it afterwards. If you were on camera, I'd let you tell your story. Because
I'm interviewing you, Judge. You're not interviewing me.
But what you learned, and I think everybody does, is the collective jury doesn't miss much. And you don't think they're paying attention. By the time they get the case to deliberate, someone on that jury, probably most of them on that jury, have seen everything.
Do you know? Have you ever noticed any difference between the state juries and the federal juries? You think there's any difference?
I do. Number one, we get a broader draw, and in that you get a broader mix of people. When they come to federal court, the matters are more substantial, and the settings and the trappings are more, I think, conducive to deliberation. And it's not a gristmill, and I think they understand that, and they respond to it. I even see it in the way they dress. It's like going to church, and you give your best effort, and I think in the federal court they do. I've tried state court cases. I used to try cases by choice in magistrate court when I was a young lawyer, 3 or 4 nights a week just for experience. And that jury, for the most part, is the same jury that you get in state court on other matters. And they pay attention and they try to get it right too. But it's a different approach because you're in magistrate court, same thing in state court. And it's not to say you don't get justice. It's sometimes more difficult to do it, excuse me, for the lawyers.
You have any interesting jury stories, Judge, you want to share with us?
Well, if you want to go back to the state system,
Either one.
I can remember trying cases as a lawyer in the state court, and right outside the jury room was a vent where, in that same courthouse we talked about, where you could hear the jurors deliberating. And the bailiffs back there would kind of bring you messages about how things were going. We haven't had any like that here, but I had a very serious rollover death case, a Ford 150. It was a products liability design defect case. Took a month to try. We had every kind of expert you could have, and the jurors bonded throughout that trial. And they brought back a defense verdict in that particular case. But during the trial, they brought me a cake. And I thanked them, and it was a nice cake, very good. And I was always taught never to return an empty plate, my grandmother, so I went and got some cookies or something, returned the plate with something on it, and they liked that. But anyway, they asked me, did I ever rap the gavel in court? I said, no, I've never needed to rap the gavel during a trial. They said, would you do it for us? We just like to hear what it sounds like. So I said, I'll think about it. Well, the lawyers came back in that afternoon, and they getting ready, and whap, I hit the gavel. They jumped in, and they didn't know what was going on. I said, everybody relax. The jury asked me to do it. And to top it all off, I get a call from that jury, from representatives. They wanted to have a reunion. And they wanted to know if I'd meet them at the courthouse on a Saturday. And they came from all over back to the courthouse to rehash their experience. And I met them down here and let them in and all that. That's probably the most unusual jury experience I've ever had.
Judge, when you have a non-jury civil trial, what kind of, I guess, thought process do you go through in coming to a verdict? Do you have any particular process?
Well, you know, it's like being a juror. You end up not only making a decision, you have to do what a jury does not do, and that is write out all the reasons. And when you find facts, you have to say what they are. So it's a lot more work when you have a bench trial. And so I keep copious notes, and so do my law clerks. And at the end of the day, each session that you're in, I circle things I find important that I want to keep, and it will probably be a basis of a finding or something of that kind. And then at the end of it, the law clerk get my notes and theirs, and they run a draft of finding of facts and conclusions law. And I tell them what I want to conclude, how I think it should go, and they go through the record and find the stuff to support it and all that. But it's a lot of work if you have a bench trial.
Now, Judge, switching to the criminal for a second, I know you didn't do an awful lot of criminal when you were in private practice. How did you adjust to having to be a criminal judge, I guess?
Well, you know, when I practiced law, I enjoyed criminal defense work. And I was on the appointment list at the federal court because I volunteered to do it. As you remember, we didn't have a public defender in the state court system, so everybody that was in the bar got appointed cases. And that might be one of those cases you thought I did in 15 minutes. You went to the courthouse, you were in jeopardy of being appointed. I went down there to get a paper signed from Judge Singletary, and there was a lawyer pleading his client guilty to rape. And it fell apart because the mother stood up in the back of the courtroom and said, that's my son, and he didn't do it. Well, the judge wouldn't take the plea, and he looks at me and said, Mr. Duffy, you appointed to help try this case. We'd start in 2 weeks. But that was the kind of thing that happened. And I've forgotten what you asked me, but state court and juries.
But just, just the adjustment to being a federal criminal judge, I mean.
Okay, the criminal part, the biggest adjustment when I came on was we had mandatory sentencing guidelines. I was totally unfamiliar with that, and they have schools on that for the federal judges, and the expert on it was a fellow right here, Rusty, was a probation officer in Greenville, South Carolina, and Judge Wilkins, as you know, at one time was a fellow that put together the guidelines and defended them. Had no problem with the guidelines, they were helpful. What I didn't agree with is the fact they were mandatory. I believed all along that was unconstitutional. The Supreme Court finally got around to saying it was. And Congress has no business dictating to judges how to sentence somebody. Why they ever allowed that, I don't know. And I ran squarely into it in an early case I had where I had to sentence a woman to 10 years whom I would not have sentenced to prison otherwise because it was a mandatory minimum and guidelines dictated it. And that's the kind of thing that's abhorrent to justice, and it was abhorrent to me. And in fact, I was a brand new judge, and Lionel Lofton represented the woman, and I had to get up from the bench, and I was going to break down trying to sentence the person. She was a college student who was on an art scholarship, who came down here to help a friend who had all kinds of problems, and the friend and her boyfriend, who was a former policeman from Ohio, had conspired without her knowledge before she came to rob a clearinghouse of Nations Bank. They did a spectacular job of it, and they used an empty gun to do it, so all the guidelines just went up. They confronted her with it the night before and said, we're gonna do this. They had children. She came to help with the children during the holiday. They were going to leave the children in the car while they robbed the place, and she sat and babysat the children, and she ends up getting 10 years in prison. Yes, she should have called. She should have told them not to do it. She should have notified the authorities, but she didn't deserve 10 years in prison.
At that point in time, you had no discretion.
No discretion.
Vary from the guidelines.
I got a letter afterwards from her mother. It's amazing how these things work out. Her mother said, we were so despondent, but seeing your humanity and your reaction to it made us understand that you had to do it, and that it was part of what she had done, and they didn't understand criticizing the guidelines or anything. And the hard part was it should not have been part of what I had to do.
Well, now that you don't worry about the guidelines so much, how do you approach sentencing someone?
That's the worst thing about being a judge, and we all hate that. And I frequently say, because it's true, and I'm sure all judges say this, when you sentence somebody, I tell the family who's there in support, I realize when I sentence this person, I'm sentencing the entire family. And they haven't necessarily done anything wrong, but they get the same grief and impact of the sentence. So that weighs heavily on you. And the other thing is the victimization and the aspect of dealing with the victims is difficult. And once in a while, a person is guilty of the crime, but the penalty is, because of guidelines or whatever else, difficult. And they've earned a sentence, but you just believe if you give them a break, they would be a productive human being and citizen. I did that in a case. The fellow was the son of the man who organized the Hells Angels in South Carolina. This boy grew up as a Hells Angel. Hells Angels in motorcycle shops are where you make methadone. And they were selling that stuff in all the shops. This boy got caught doing that. big brute of a guy. Anyway, excuse me. I was going to sentence him. His wife was a drug addict, and she left him with a young daughter. And I've forgotten how old she was, 6, 8, something like that. And he told me that if I gave him a chance, he would do anything not to leave his daughter alone and be sent to somebody to care for. And if he came from a Hell's Angel family, no telling where she would have gone. So the guidelines in the judge's school don't tell you what to do in those circumstances. So I made a deal with him. I said, I'm going to postpone this hearing for a year. And if you do everything you told me that you're going to do for the sake of this child, I'll bring you back in here a year from now. And if you've done it, I'll work out something on your sentence. He completely rehabilitated himself. He got off methadone, left the motorcycle gang, took care of his child, did everything a good father would do, and he came back into court with that record. I told the U.S. attorney, I said, I'm going to give him community service, long-time supervision with requirements for drug checking and all the rest of that stuff. But I'm sending him home with his daughter. I'm not putting him in jail. If y'all want to appeal it, go ahead. They didn't want to appeal it because they understood. Drug court that Judge Hendricks started here, she invited that man and his daughter to come speak to the drug court. He came back, his daughter was like 13 years old. He's a martial arts guy. Now she is. They go around teaching martial arts and have what do you call it, judo studio type places. And it's a success story. He's still on the straight and narrow, and his daughter's leading a great life. If I'd have followed the guidelines, they'd both be in prison now. So that's the deal that I used to worry about.
How about lawyers, Judge, that I know favorite subject, that appeared before you? Lawyers generally prepared, that have appeared before you?
You know, the good thing about federal court is generally the issue is significant enough and the amount of money involved is significant enough that the lawyers are prepared because the good lawyers have been paid to be prepared. Every once in a while you get somebody that just got a case and came to federal court and doesn't know what to do with it. And that's kind of sad. And if the client has a good case, I've tried to settle those cases so that the client doesn't walk away with nothing or less than they deserve, and been pretty successful at doing that. But if they go to a jury, I can only let them try their case. I can't try it for them, and it's sad to see it if it's mistried.
How about civility among lawyers in your court?
Civility has gotten, it wasn't as great as it was when we practiced because it was natural then. Now it's kind of enforced, and there's too much television about law and courts, and everybody tries to emulate or copy what they saw on TV. We had a case here, and it was a sad case. There was a fellow who was a crackhead, a crack addict as they refer to it, who robbed a Piggly Wiggly store with a knife, put it to a clerk's throat, and Rivers Avenue, went across the road with police pointing guns at him and held up traffic on 4 lanes of highway, and he wouldn't drop the knife, and he was high on crack. And they went to try to arrest him, and he tried to stab one of the officers. They shot and killed him. Well, they brought a civil rights case on his behalf, and I could have directed a verdict because they didn't have a case, but I let them put the case up because I thought it was important to the black community to know that they had a day in court. And at the end of their case, I could have directed a verdict, but I got the defense, which was the City of North Charleston Police Department, to put up their case. When it was all in the record, then I directed a verdict for the defendant. even with all of that, the NAACP had a rally outside saying there's no justice in the federal courts. But that didn't bother me. They had every right to do that. They were just misguided in how they viewed the case, and I thought it was sad that the family went away thinking that because of what the political rallies were saying. But importantly, during the trial, one of the defense lawyers, a witness who had been subpoenaed to testify by the government, this man had come into the shop and asked him to hone down and sharpen that screwdriver that he could use as a weapon, and the man refused to do it. And he left and got a knife and did what he did. Having watched television, he asked this, the defense lawyer asked this witness, whom he could get nothing from on cross-examination because he was just a working man that had been subpoenaed, and said what he knew. Said something to the effect that you can step down, and like they say on TV, I don't have any use for this witness or further use for this witness, playing to the gallery kind of thing. And I called him up and I said, I respect everybody in this courtroom, and you will respect everybody in this courtroom. You apologize to him. I mean, that kind of thing should never happen in a court, and that's where it went. Had another one, civil case, similar, experienced lawyer, said that the client he was questioning was just as obnoxious as his lawyer. I made him apologize in front of the jury too, but we never used to have that kind of thing.
The federal system, the judges seem to take a little different attitude about settlement cases in the state system. What is your attitude about trying to get this case settled? And what techniques do you use to get the case settled?
Well, first of all, understand, and you do, that every scheduling order we have, we require mediation. Unless the parties have a reason not to, we won't make them mediate if it's going to be futile. So they try that up front or during the course of the discovery. And I had a personal practice that just before trial, when they're getting ready, I'd call them in and say, look, you've mediated the case unsuccessfully. If y'all would like me to get involved and try to help you settle it, I will. But I'm not going to if you're not interested in it. If they said yes, I would have kind of a pocket mediation. I was familiar with the case from the file, and I'd meet with each one individually and find out whatever they wanted to say, good or bad, about their case or the other side's case. And then I told them, with their clients present, I'm going to give you a figure that I think is fair to both sides after having heard what everybody has to say. And I'm not splitting the baby. I'm going to tell you what I think is fair. And be amazed how many times that was right. And they settled cases. I'd say, you asked your client and report to me, not the other side. Same thing. If both agreed and it was settled, I'd say it's settled. If either one said no, I'd wait till I got both answers and then say the case is not settled, so nobody would know. But I only missed badly in one case, and that was because the plaintiff's lawyers were totally unrealistic and valued a case, and they skewed my opinion of it. And the defense lawyers were way lower, and they ended up being right. They tried the case and got that verdict. On another one, I had a big case, and I tried to get the defendants settled, and they wouldn't, and the jury brought in almost the exact figure I asked for them to settle. So it was a pretty good way of getting rid of a good number of cases, and it worked, I'd bet, in the large majority of the time.
Is it true, Judge, now that there are fewer and fewer cases being tried in federal court?
Absolutely.
And what are the reasons?
To the point, it's almost, the animal is almost extinct.
The jury trials are almost extinct in federal court.
Yeah, and it's sad. For the lawyers, it's sad. I tend to believe it's all due to mediation, and it makes sense because mediation is less risky and less expensive. And I tell lawyers, you know, the same skill set that you use in trying a case, you use in mediation, and you got a tougher jury. You got to convince the other side rather than a jury to settle because of what you say. And you can control your fate with mediation, and I think people like that as opposed to arbitration, which is binding. And I'm doing some mediations now, and for the same reason, I find it is so much less costly and so much less scary than going to a jury.
You mentioned earlier that you sat in some other circuits. I think Arizona you mentioned, I believe.
I tried cases along the border in New Mexico because they're overwhelmed with cases, mostly dealing with illegal immigrants and border crossings. They only had one federal judge in Las Cruces. He was a friend, and he had back surgery. And he had the largest caseload in America. He had 2,000 cases, and he was the only judge. So I went down, and I would take guilty pleas for a week or try a case for a week or what have you, trying to help out. And I went to sit with the 11th Circuit in Florida at Miami Court of Appeals, and they asked me to sit, and I said, I'll do it, but I'm not going to Atlanta. I said, I have enough of Atlanta. And so they said, would you sit in Miami? And I did. And we went down, and a lot of the cases we had were maritime cases and sanctuary cases. And it's amazing because of the countries you see now coming across our border, people who are fleeing from horrible situations. And watching the news, it's interesting to me. Sanctuary is such a difficult thing to grant because of the law. All of these people have terrible tales to tell and horror stories in some case, and still doesn't meet the requirements of sanctuary. And I was shocked by that when I first got into it because we never have sanctuary cases. And that's another thing about federal practice I didn't realize until I came on. Geography determines a lot of what your docket is. And if you, for example, in New Mexico or Oklahoma, you might have what is in essence a family court docket because the Indian reservations, the Indian nations come to federal court. You get child molestations and all that stuff comes to federal court. So I'm glad I'm not sitting in one of those jurisdictions, but these others were interesting and I enjoyed doing it and helped out. The one thing with the border stuff, I didn't agree with it at all. I'd show up and they would have people lined up with agreements to plead guilty and sentence them. And they'd agreed that the sentence would be, they'd be deported. Well, these people have been deported 10 times. And I said, look, I'm not going to come down here and throw a monkey wrench into what's been agreed to. I did 95 sentencings in 1 week, and the most of them were that kind of thing. And I would tell every one of them, I said, now you stand there and tell me you're not going to come back. I said, I'm going to tell you right now, I don't believe you. I said, but I'll tell you this. If you come back to South Carolina, I said, you better stay in New Mexico. If you come back to South Carolina, you're going to jail. It's not going to be you going back across the border again. It's absurd. Waste of assets, an insult to the court, and a disservice to everybody involved. But it just happens. Clears the docket.
Judge, I heard one time that Senator Graham, somewhat tongue-in-cheek, said that he was going to put your nomination for the U.S. Supreme Court, and that you told him you had a better job than that. No, thank you. Is that true?
That is absolutely true story, and I absolutely felt that way. You know, the things I enjoyed doing, like going to the Hibernian to have a beer at the back bar or some of the other activities I've described here today, a Supreme Court justice can't do. And they lose their anonymity and they lose their privacy and their families are invaded. Right now, I don't know who would offer for a seat on the Supreme Court, given what the ordeal is to stand before the Judiciary Committee. It's an abomination and it's wrong. I don't care which side's doing it. Both sides have done it. But what it's done is totally politicized the one branch of government that wasn't. And it's not what the Founding Fathers designed. It's not what we want. And I resent it. So I have a little something to say about it. And it's all angers me, to be blunt. I'd like to get back to what the Constitution says, advice and consent, make sure the person's qualified. You don't get to pick the person. I don't care which side you're on or who the nominee is. And I think Lindsey Graham got it pretty correct when he said, I always supported the Democratic nominees. If they were qualified, I don't get to make the pick. I wish all the senators would think and feel that way.
Now, Judge, why did you decide to retire?
Well, I'm 76 years old. Between the bench and practicing law, I've been at it 50 years. And as you can tell from my frequent breaks I took today, I'm not the man I used to be. So I'm going to travel with my wife and do all the bucket list things that we want to do together. And I've got 7 beautiful grandchildren, and they're getting to the ages, while they still like Pops and Mimi, that they will soon not want to be doing things with us. And those are the things I long most to do. So that's why I retired.
You think you're going to miss it?
Well, I miss it, but anything, if you like your job, is a bittersweet experience. Here, it was especially difficult because the position is a wonderful position. The other judges are so collegial, and the support staff is so wonderful. I can't think of a better position or workplace than being a judge in a U.S. District Court. And I will count this above any appellate court, be it Fourth Circuit courts or any others, 11th, you name them, or the Supreme Court, because this is the only place you get to deal with people on a day-to-day basis. You get to deal with cases as trial lawyers do, which I loved. Appellate work is very sterile, and it's not the same reward. If you want to be on the Supreme Court and you want to sit somewhere where it might boost you to that, more power to you. But if you're looking for job satisfaction and enjoyment in the job, I don't know anything better than what we had here.
Judge, that's about all I have. Do you got anything else you want to add to this oral history?
Donald, I can't think of anything, but I know 2 things I want to say. One is I kind of jokingly said about Katie, I did say enough about her because she's got enough accolades, but I want to say what a wonderful job she's done for her family, traveling around the world, doing things that she's done. Her husband, Mark, I wanted to say, deserves tremendous credit. He's a bond trader, started out in currency trading. He takes a computer and works from home, and he works different hours depending on where they're stationed, and he does it without complaint. And he's like my other 2 adopted children, in-laws to my children. Wonderful. They just loved as much as our own children. And I want to say something about my wife, though I might have said a lot about her already. I can't say enough. She is without a doubt one of the most brilliant people I've ever met, one of the most industrious people, and all those things that you'd say about somebody who's talented and dedicated to what they do. But she's also one of the most caring people, and I want to say this in a way that's understood. Without regard to religion, without regard to ceremony or dogma, she is the most moral person I've ever met. George Washington was a figment about chopping down the cherry tree. Kathy Duffy can't tell a lie. I'll tell you a quick story to prove it. She has no guile in her, and she cannot do anything but tell the truth. We were going to a Spoleto finale years ago at Middleton Place. No wine or anything, beer or what have you, in the premises. Well, she had a bottle of wine. We're sitting on the lawn, and you had to go through a checkpoint. And the kids were adults, and they had a bottle of wine in their cooler and blanket. And they said, Mom, what you going to do when you get to the gate? Because they knew she couldn't lie if he asked. And the fellow says to her as she's going through, do you have any wine in your cooler or something? She couldn't answer the question. She said, I have my tickets. He didn't stop her. He let her in, but she could not say that she didn't have a bottle of wine. Well, that's just a cute little example of the person she is. And I want her to know it didn't go unnoticed by this rogue of 53 years. I love her to death.
Great.
Thank y'all.
Thank you, Judge.
I want to say it's probably obvious from what we just put on tape that Donald did a great deal of work in preparing this outline and questioning, and I want to thank him for that. But more than anything, I want to thank him for being a dear friend and a great law partner for many years.
Thank you, Judge.
And I wanted you on this side of the camera so posterity can see you with me.
I love you to death.
Thank you, sir. It's mutual. Doug, thank you.
Thank you, Judge.